Court, rise if able. This is an appeal on behalf of ASJ and the Secretary of State for the Home.
Yes.
Lords, I appear for the appellant who is sitting at the back of the court.
Yeah.
I'm instructed by Mr. Atta, and my learned friend, Mr. Malik, appears for the Secretary of State.
Yeah. Well, we've read the papers and we've got I think, a lively appreciation of the two issues. So you can take that as read when you make your submissions.
My Lord. Well, I mean, I would say that in this case there is a fundamental principle of refugee law that the asylum seeker is to be given the benefit of uncertainty when a decision on an asylum claim is made. And in this case, on a critical issue, instead of giving the benefit of uncertainty to the asylum seeker, the tribunal gave the benefit of uncertainty to the Secretary of State. And that is an error of law, a material error of law. When I refer to the benefit of uncertainty, I mean two things. First of all, that it's sufficient for the asylum seeker to establish a reasonable degree of likelihood that the harm feared will eventuate. And it also means that to establish that reasonable degree of likelihood, it is sufficient that there is a real possibility or a reasonable likelihood that the asylum seeker's account is true. But instead of approaching the appellant's appeal in that way, the tribunal gave the benefit of uncertainty to the Secretary of State, and she dismissed the appellant's appeal because she found there was a reasonable likelihood that he would have clan and family support in Mogadishu, and therefore it would not be unduly harsh for him to go there. So that in outline is my case. And what I would like to do is to take you briefly to three authorities to make good propositions that I have asserted, and then to take you to the tribunal's decision to show how it falls foul of those principles. So the first authority, and I will only take you to it, the briefest look at it, is Siva Kumaran, which is at tab 1 in the bundle of authorities. And if you could turn, please, to page 994, you will see there the judgment of Lord Keith. And just below the letter F, he says, in my opinion...
Sorry, page?
Page 994 of the report.
Yeah.
And just below the letter F, he says, in my opinion, the requirement that an applicant's fear of persecution should be well-founded means that there has to be demonstrated a reasonable likelihood, a reasonable degree of likelihood that he will be persecuted for a convention reason if returned to his own country. And the other judges either made statements of principle to similar effect or agreed with what Lord Keith had said. So at page 996, at C, Lord Bridge agreed with Lords Keith, Templeman and Gough. Then in Lord Templeman's judgment at the letter F. He said that the Secretary of State accepts that an applicant who fears persecution is entitled to asylum in this country unless the Secretary of State is satisfied that there is no real and substantial danger of persecution. Then at page 997, at the end of Lord Templeman's judgment, he expressed agreement with Lords Keith and Gough. And then Lord Griffiths at C similarly expressed agreement with those judges.
Is there anything else specific?
Not that I, no.
You don't need to see agreements, just in general, couched in general terms. You go to this case for the bit on page 994 between F and G.
Yes.
That's well accepted, that is the test, reasonable degree of likelihood, burden on the appellant, and that's what the tribunal says.
Yep. I'll move on from Siva Kumaran then to Karana Karan, which is at tab 3. And could I take you first of all to page 456? This is in Lord Justice Brooks' judgment, and at the very bottom of the page.
Which page, sorry?
456, my lord.
Yeah.
2 lines from the bottom, he says that the issue that has arisen for decision in this case relates to the method of establishing whether it would be unduly harsh to expect an asylum seeker to live in a different part of his own country. So that's the issue in Karana Karan. And I would then like to take you to, well, actually just in passing, page 459. Lord Justice Brooke had described what the majority of the tribunal had decided in the case of Kaja. And just below the letter F, or at the letter F on page 459, again, this is describing the majority's decision. He said, to say that it is only the facts established as more likely than not to have occurred on which the reasonable likelihood must be based would be, they said, to remove much of the benefit of uncertainty conferred on an applicant through ex parte Siva Kumaran. And I take you to that just to show where I get the phrase the benefit of uncertainty from. Could I then take you please to page 4...
Sorry. Show me that passage again, page 459.
459 at F.
No, thank you.
That's because they applied a different and higher proof, balance of probability, more likely than not.
That's what the minority in Kaja decided. But here Lord Justice Brooke was describing the majority decision. And the majority's decision was that to apply the balance of probabilities to the determination of historical facts would be to deprive the asylum seeker of the benefit of uncertainty that was conferred by Siva Kumaran.
That expression, benefit of uncertainty, that's not actually used by the House of Lords in Siva Kumaran.
No, that's quite right. It's not used. But it's used, as I say, in Kaja, and Kaja is approved.
Is that a phrase used? Is that because this is Lord Justice Brooke describing that case? So is that phrase Lord Justice Brooks, or is that phrase the tribunal in Kaja?
I think it is the phrase used by the tribunal in the Kaja case. They talk about, the majority talks about a positive role for uncertainty.
So that's the tribunal.
That's the tribunal, yes.
Yeah.
Could I then take you please to page 469? And it's just above the letter G. Lord Justice Brooke says, in the present public law context, where the country's compliance with an international convention is in issue, the decision maker is, in my judgment, not constrained by the rules of evidence that have been adopted in civil litigation and is bound to take into account all material considerations when making its assessment about the future. This approach does not entail the decision maker, whether the Secretary of State or an adjudicator or the Immigration Appeal Tribunal itself, purporting to find proved facts, whether past or present, about which it is not satisfied on the balance of probabilities. What it does mean, on the other hand, is that it must not exclude any matters from its consideration when it is assessing the future, unless it feels that it can safely discard them because it has no real doubt that they did not in fact occur, or indeed that they are not occurring at present. Similarly, if an applicant contends that relevant matters did not happen, the decision maker should not exclude the possibility that they did not happen, although believing that they probably did, unless it has no real doubt that they did in fact happen. For the reasons much more fully explained in the Australian cases, when considering whether there is a serious possibility of persecution for a convention reason, if an asylum seeker is returned, it would be quite wrong to exclude matters totally from consideration in the balancing process, simply because the decision maker believes, on what may sometimes be somewhat fragile evidence, that they probably did not occur. Similarly, even if a decision maker finds that there is no serious possibility of persecution for a convention reason in the part of the country to which the Secretary of State proposes to send an asylum seeker, it must not exclude relevant matters from its consideration altogether when determining whether it would be unduly harsh to return the asylum seeker to that part, unless it considers that there is no serious possibility that those facts are as the asylum seeker contends. So that, I would say...
But no, you really do have to go on, because Lord Justice Brooke is making a broad discussion of matters. And in the next paragraph, it says it has to reach a well-rounded decision, and that necessarily involves giving greater weight to some considerations than to others. And then he accepts really D to E. The decision maker should simply ask, would it be unduly harsh to expect the applicant to settle there? In answering this question, it may have to take into account the cumulative effect of a whole range of disparate consideration. It's really saying you can't leave anything out of account, and you've got to consider everything and see where you think you are. But a lot will depend upon the particular fact that you're looking at, whether it's an historic fact, was I beaten by people in Mogadishu, or whether you're looking at the likelihood of being able to get support. He's not trying to lay down an absolute rule there, is he?
He's not. Well, there is a rule there, which is that the decision maker must not exclude matters from consideration.
That's correct. That's what you see in every other case, and you're not suggesting that happened here.
Well, I would say that that is in fact what happened here, because the tribunal...
You say it excluded matters.
It excluded the appellant's factual claim that he would have no family or kin support in Mogadishu, and that he would have nobody to provide him with remittances.
So you say that the tribunal was bound to accept that?
I would say that the tribunal...
If that's your principle, and you say that here the decision maker did exclude the appellant's factual claims, so the principle must be that they were bound to accept them?
Yes, unless the tribunal concluded that she had no real doubt, but that the appellant had family and kin who would support him.
Well, the kin comes from, you haven't put the latest country guidance case in the bundle, you put the earlier one. But the latest one confirms that if it's a majority clan they support, the Upper Tribunal goes on to find that this is a minority clan on the part of the appellant. And then it says little practical support, but might give some support with accommodation. And that's the extent of the support. And she's entitled to do that, isn't she? She's entitled to rely on the country guidance that says if it's a minority clan, there will be minimal support. That's all she said.
Yes, I mean, the OA, the latest country guidance case, is not in the bundle of authorities because the relevant I don't take any issue with the way that the judge directed herself in accordance with that case, and I'll take you shortly to how the judge directed herself with reference to OA.
Well, that does say, OA does find, doesn't it, when dealing with the country conditions, that minority clans do not have much by way of support. It's different from majority clans, and the Upper Tribunal correctly identified that this was in the minority clan limited support. And she's entitled to do that, isn't she, or is she not?
Well, she is, of course, she's certainly entitled to do that. But the problem is that she was entitled to, and indeed obliged to, apply the country guidance, which is to the effect that there would be potentially some support available to him provided by a minority, his minority clan, albeit not equivalent to what he might receive if he belonged to a majority clan. I accept that that's what the country guidance that she cited requires or enables her to do. But she also properly addressed the question, did the appellant have a network that would facilitate his access to such support as the minority clan in Mogadishu could provide? So it's not, as she found the facts to be, it's not as simple as saying that because one belongs to a minority clan, one will automatically have such support as that clan.
What OA says, which you haven't put in the Bible and is hugely relevant, is that the way it works is by way of networks and very strong obligations, and the diaspora assists. So the starting point is there will be minority clan support. It operates by network. And you want us to accept that because the appellant says, no, I have no access at all to any member of the diaspora, to any member of the minority clan. Therefore, I will not even have the minimal support that they say. That's what you want us to decide, is it?
I want you to decide that the judge, maybe I should take you to the way that the judge dealt with the issue. So her judgment begins at page 49 in the bundle. Yeah. At page 55, or beginning at page 54, at paragraph 11, she sets out the head note in OA.
Yep.
And it's at paragraph 14 in the head note that she sets out what OA said about internal relocation. It will only be those with no clan or family support who will not be in receipt of remittances from abroad and who have no real prospect of securing access to a livelihood on return, who will face the prospect of living in circumstances falling below that which would be reasonable for internal relocation purposes. So she's given herself the direction that she needs to apply this country guidance, and that is the key passage in relation to internal relocation. And then she applies that at paragraph 30 in the determination, which is at page 61. So she begins there, it's accepted that the appellant has never lived in Mogadishu. He is from a minority clan. I've taken
Well, you need to start at 29 when she, because you've taken us to the head note in OA, but there's about 350 paragraphs, and around paragraph 250, the judgment, which you haven't put in the bundle, deals with minority clans and networks. And at 29, she starts by saying why you can call on your minority clan people. So don't we need to bear that in mind?
I accept that that needs to be borne in mind.
Because she says that the country guidance says there are extensive links and that there's a kind of non-negotiable cultural obligation to help one's kinsmen. She then deals with the aunt and uncle and the mother coming from a different clan. Then she deals with the separate point about who's funded the trips in 2018 and 2019, and then she comes to 30.
Yes. Well, this is where she deals with the point about the assistance that may or may not be provided to him by his minority clan. And so 4 or 5 lines into the paragraph, she says, having made reference to what OA says about clans and minority clans, she says, accordingly, I find that it is likely that there will be some clan support available to the appellant. I accept that the links necessary to obtain this assistance must be established through an existing network. So just pausing there, she's identified a factual issue to be decided, which is, does the appellant have an existing network that will enable him to gain access to the clan support that is available in Mogadishu? And bearing in mind that this is an appellant who never lived in Mogadishu. He left Somalia in 2014, so
She's
around
made the various findings of fact.
I beg your pardon, my lord.
We're looking at principle. The findings of fact are in the judgment.
Yes.
It's the principle. You were telling us why this paragraph 30, contains an error of principle. I think that's what you were doing.
I do say that, yes.
Yeah. Well, I think rather than rehearsing the facts, don't we need to identify what the principle is that you say paragraph 30 shows an error in relation to it?
I mean, I would say it's important to identify the factual issue in order to see the principle that is being applied and whether the judge...
We get quite a bit of that from paragraph 29, which you didn't take us to.
Well, paragraph 29 is the paragraph that introduces the factual situation, which is that clan-based support is available in Mogadishu.
Yeah.
So I felt that by taking you to paragraph 30, it crystallises the factual scenario that has been...
Just tell us what the point of principle is. You say in paragraph 30 there's an error.
Yes. Well, first of all, she said that it is necessary to have a network in order to access such protection as is available. And in the last sentence in paragraph 30, she says, I find that it is reasonably likely that he has a network to identify links with his minority clan in Mogadishu to seek assistance with accommodation. So the existence of such a network is a necessary precondition for gaining access to clan support in Mogadishu. And the judge here has found only that it is reasonably likely that he has a network to...
Yes, but that's based on the other finding she's made, that he hasn't been truthful about the extent of his obligations, and somebody has paid for 2 flights.
Yes.
So there are other people in the diaspora who are helping him. And the links in England and Sweden, and their links with minority clan members in Mogadishu, because there's the strong, compelling obligation, which people from Wales fully understand, that one group supports another group. And that's what she said.
Well, what she has said...
So she hasn't excluded it. She doesn't believe the appellant as to the extent of the support, and the reason why is somebody has paid once for an agent and once for a flight.
Well,
somebody paid in 2014 for the mother and the children to get out.
yes, well, I mean, that is indeed the reasoning process that the judge adopted. But the degree of certainty with which she expressed the conclusions that she arrived at indicates that she failed to apply the principle that I say she was required to apply.
Which is?
That she should have given the benefit of uncertainty to the asylum seeker and excluded matters upon which he relied only if there was no realistic possibility that he was telling the truth.
But somebody has paid for the agent and the flight, so why does she have to exclude that?
Well, can I just show you the conclusions that she...
Why does she have to? That is a fact. Somebody has paid for the flights. They weren't given to him free. He's never suggested he had a free flight or a free agent. So why should the judge have to exclude the fact that flights and agents were paid for, and then to draw reasonable inferences from that? That's what I don't understand.
Well, the fact... The important fact is not that somebody paid for him to travel to Sweden and then to the United Kingdom.
Twice.
The material fact is, does he or does he not have family and kin who will support him if he goes back to Mogadishu?
Yeah. And she's
And
made
so
findings of fact about the support in the past.
So she's drawn inferences from the fact that he was able to raise...
Made findings of fact.
She made findings of fact.
She made findings of fact about support in the past. And then she goes on, as a result of that, to make findings as to what's likely to happen in the future.
Right.
At the moment, I'm struggling to say. I'm sure it's my fault. I don't understand what the problem with that is. You say you could only exclude the applicant's position or case if there was no realistic prospect that he was telling the truth. But she finds that he had not disclosed the full extent of clan family support available to him. So that's why I go back to the point that you appear to be arguing that, notwithstanding the fact that she's made a positive finding there against the applicant, that she was still obliged to accept his case.
Well, if I could go back once again, if I may, to Karana Karan, page 469 in the judgment.
Yeah.
At the very bottom of page 469, on the right-hand side of the page, Lord Justice Brooke says, it would be quite wrong to exclude matters totally from consideration in the balancing process, simply because the decision maker believes on what may sometimes be somewhat fragile evidence that they probably did not occur. So
the judge has gone far beyond that, though.
The judge has not even gone as far as to say that they probably did not occur. All the judge has said is that it is reasonably likely that the appellant has support.
But take it in stages. There was a flight on the 28th of November, or October 2018. Is she entitled to assume that somebody paid for it?
Well, somebody must have paid for it, yes.
The story was that he came with an agent first time round, and the second time he didn't need an agent because he'd found a passport that he could use. So is she entitled to take account of the fact that somebody's paid an agent? Not a small amount of money usually, but somebody's paid an agent in 2018. Is she entitled to regard that as a fact?
I accept she's entitled to regard that as a fact.
Is she entitled to take the fact that somebody paid for the flight in 2019?
I also accept that she's entitled to...
And she finds that the aunt and uncle can't pay for it, he can't pay for it, so somebody else has paid for it.
Yes, right. But I would say that it is a leap to go from those factual findings to the conclusion that beyond real doubt, that there's no real doubt, but that the appellant would be supported adequately by family members.
But he hasn't explained who else has paid for the agent and the 2 flights. He's deliberately not told the tribunal that. So what is the tribunal supposed to do? Say, well, there's this large amount of money that's been paid. He wouldn't tell me where it's come from, but I can't possibly lead to the conclusion that there's somebody who will give him some degree of support, because he says that's not true, even though I don't believe him. I mean, what are you saying the judge can do in those circumstances? It's unreal, isn't it?
Well, a judge might in those circumstances say that given those matters, given that he was able to afford tickets to the United Kingdom on 2 occasions, given those matters, I am left in no doubt at all but that he has family or kin who will send him money if he goes to Mogadishu and will introduce him to members of his clan if he goes to Mogadishu. If the judge had said, I'm left with no doubt by the evidence that that is the state of the facts, then I wouldn't be here arguing about whether she made an error of law. If, on the other hand, the judge had said, I think it's more likely than not that the appellant has got kin who will send him remittances and introduce him to his clan. If she'd said it's more likely than not, because he was able to afford those journeys, it's more likely than not that he has supportive family, then on the authority of Lord Justice Brooke's judgment that I've taken you to, it would be wrong for her to exclude.
She's
the
not
possibility that
excluding
he-
it.
Beg your pardon, my lord?
She's not excluding it. She's deciding on it. You've got to look at everything, the circumstances in the country and the appellant's circumstances. But it's not exclusion. It's simply that you don't like the fact that she's come to a decision on it. You say she can't come to a decision on it because the appellant has said, no, that may not be true. He hasn't told her what is true, where the money came from, but he's told her that her assumption, her inference that it's come from somewhere and it's likely to come from family or clan, it can't be relied on.
It's not a sufficiently compelling inference. I mean, the fact that he had in years previously had money given to him to travel to the United Kingdom, it's not obvious by itself that establishes that he must have adequate support if he goes back to
Depends on the
Mogadishu.
facts.
Beg your pardon, my lord?
It depends on the facts.
It does depend on the facts, and so what we need
So obviously, this is the fact-finding tribunal,
it's the fact-finding tribunal.
and the judge has found those various facts as to the financial support, and the judge has also found that the appellant has not been honest or frank with the tribunal and has not disclosed the support. So, as my lord said, what is the judge supposed to do in those circumstances?
The judge is supposed to decide.
And she did.
Well, she decided that it was reasonably likely
Yeah.
that he had.
So it really does come to the language of one phrase in a judgment.
Well, it's not one phrase; it's a phrase that she uses repeatedly.
It's a what? Sorry.
It's one phrase, but it's a phrase that has got.
Used repeatedly.
It's used repeatedly, and it has got.
Reasonably likely.
Yes.
Where else do we find that?
Well, look first of all, please, at paragraph 28
Of the judgment.
of the judgment. Yes, about halfway down paragraph 28. She says, however, what is clear is that the appellant has family or clan links in Europe, which I find are reasonably likely to be wider than just his aunt and uncle.
Yeah.
So it's a reasonable likelihood. It's not. She doesn't say.
Not out of thin air. Somebody has paid for the flights. She's already had the statements from the aunt and the uncle. It's not the aunt and uncle. They can't afford it. They're willing to give him accommodation, but she says, I can't assume from that. And she finds that they didn't pay for the flights. She accepts he's got no contact with the mother. So somebody has paid for the flights. He hasn't come forward and said, I won a scratch card competition. He hasn't explained where the money comes from. So where else, or why can't she draw the conclusion that the undoubted expenditure of money on an agent and a flight, coupled with the undoubted expenditure a year later on another flight, why can't she conclude, well, somebody is supporting him, his family or his clan? If it's a friend that he's met in Sweden who's Swedish, I suppose you could say, well, that's not clan or family, but then the friend would support him if they're prepared to shell out for an agent. Once the money's been paid, you've got to address the money.
You have got to address the money, and the judge had to show that she had drawn a lawful conclusion as for the purposes of the internal flight question or the refugee status determination, that she had lawfully.
Yeah. So instead of, in paragraph 30, if instead of it saying it is beyond doubt that he has a network, then you say there wouldn't be an appeal.
I'd say there wouldn't be an appeal. If she'd said, yes, I find I'm left with no doubt at all, but that he has got supportive family and kin who will send remittances to him in Mogadishu and will introduce him to his clan, then I wouldn't be here. If she had said,
no, I'm just looking at we are within the bounds of the judgment.
yes,
Still. So penultimate line of paragraph 30, I find that it is reasonably likely. You've explained that you say that's erroneous in law. And I was saying, if she had said it is, instead of reasonably likely, beyond doubt that, then you say you wouldn't be here.
yes, I say I wouldn't be here.
Just those two words.
Those are two words which have got a very well established meaning in the determination of refugee cases, that normally it is sufficient for the asylum seeker to make his or her case if the asylum seeker establishes a reasonable likelihood that the facts are
The
as
asylum
claimed.
seeker here didn't establish anything because he didn't disclose the extent of his clan and family support. He was not frank with the tribunal. But you say that doesn't matter, and she was still obliged to find effectively for him.
Well, I mean, the fact that an appellant has been, on her findings, less than candid or less than frank, does not necessarily and does not automatically lead to the conclusion that therefore the appellant will have people who not only will have paid for a ticket to the UK, if that's in fact what happened, but that they will on a long-term basis provide regular remittances.
That's not what OA requires. It's not a long-term basis regular remittances. It's some support to get him established in Mogadishu. And the accommodation is going to come, they think, through links from the clan, and there'll be some support by way of remittances, but one mustn't overstate what it is that has to be provided. The Refugee Convention in UNUSI and HA in the House of Lords and SE, which you haven't referred to, and which are the current binding cases, make it quite clear. It's quite a stringent test. It's not to ensure that he has the same level of life there that he would have here. It's simply that it would be unduly harsh if you've got no prospect of re-establishing and reintegrating. So it's not long-term remittance. He's a young man who's expected to work there.
Well, it's remittances for as long as he requires it or needs it to avoid destitution, to be able to cope with the dire humanitarian situation in Mogadishu. So if I was suggesting that he needs for the rest of his life to have remittances, then I accept that that is wrong. He does, however, well, the judge found that he would receive remittances. So that's more than just whatever money somebody gives him to put in his pocket when he goes. It is somebody being willing to send money to him on a...
That's what she finds, yes.
Yeah, so she found that that would happen, but she found only that it was reasonably likely that that would happen. So a reasonable likelihood that that would happen is not sufficient to...
Well, in 32, she said, I find that the appellant would have remittances from abroad and some clan support.
Well, that's because previous...
So your magic words aren't there.
Well, no, I mean, the obvious...
I mean, it's not a statute, Mr. Toll. This is a judgment. You have to look at it holistically.
You have to look at it holistically, but one is entitled, I would say, to treat the words that the judge uses as being indicators of the judge's thought process. And the judge, as I say, repeatedly uses the phrase that
Well,
she
makes
finds...
a finding in 28 and a finding in 30. And we have your
and also in
submissions
29, my lord. If you could, at the second page of paragraph 29, 3 lines from the top of the page, she says, however, I find that the appellant has not disclosed the full extent of clan family support available to him. I reasonably infer that the person or people who helped the family in 2014, 2018 and 19 are reasonably likely to be able and willing to send remittances to him in Mogadishu.
Well, we have your submission that on your case that's not enough, and if it had been each time beyond doubt, then it would be all right, but because it's reasonably likely, it's not giving the applicant the benefit of the uncertainty.
Yes, I mean,
And that submission.
yes, I mean, even if the judge had said, I find it
Oh,
more
we
likely-
understand that, that
Yeah.
submission. I don't think we need, that's the submission. I don't think we need to be rewriting the judgment beyond that. That's either right or wrong.
And my lord, you made reference to paragraph 32.
Yeah,
I find that the appellant would have remittances from abroad and some clan support. But that finding is a finding on the foundations of the reasonable likelihood that she has mentioned 3 times in the previous paragraphs.
If we forget the words reasonably likely and so on, and say inference, is that acceptable? He's had money twice recently. I infer that he'll have money again. He hasn't explained how he's had that money, but I infer that it's come from family or clan. Is that, if you drop the word reasonable and said inference, and then you come to the conclusion in 32, would that be all right?
And I would say not. I mean, I would say that the the reason why the judge has said reasonably likely, I would suggest, is because it does not automatically flow from the historical provision of some funds, that he has kin and people in Europe who will send remittances and introduce him to his clan.
Where else has it come from? He hasn't told her what she's supposed to do.
Well, I
It
mean,
came from somewhere else. Why didn't he just say?
I mean, it's unfortunate that one can't tell from the determination what discussion, if any, or what evidence, if any, there was about that issue. I mean, it's a lacuna in his evidence. He didn't
The
say.
burden of proof is on him.
The burden is
He must establish to a reasonable degree of likelihood that internal relocation would be unduly harsh. He's getting money and he hasn't explained where it's coming from. And the inference is, if they've helped him in the past to try and get to the United Kingdom so he could get protection here, they'll help him when he goes to Somalia to help him get set up there.
yeah,
That's
and
all
yet,
he's saying.
and yet, all that the judge feels able to infer is that it is reasonably likely that he has such family, and it's reasonably likely that they would make remittances to him. That's all that she feels able to infer on
and we
that.
have your submission.
Yeah,
You say that's not enough.
I do say that's not enough.
And we understand that. You can't take it further than that, can you? I mean, that's the submission.
That's the submission, yes.
And so, at the moment, going back to the question I asked you originally, I'm not clear. The judge hasn't excluded anything on my reading of it, has she?
Well, she has excluded the real likelihood that he will not have support. She has decided that he will have support.
She hasn't excluded anything. She's reached a view on the facts. You say it's not couched in sufficiently strong terms. We understand that submission, but she's reached a conclusion on the evidence that was presented to her. There's nothing she's excluded.
Well, she has made her assessment of whether it would be unduly harsh or unreasonable for him to relocate to Mogadishu on the factual finding, amongst others, that he would have remittances and he would have an introduction to his clan. So by deciding that issue on the basis of those factual findings, she has excluded the real risk or the reasonable likelihood that he will not have.
But if that's based on his account, you must give the benefit of doubt to the appellant. And if he says something you're not sure, you give him the benefit of the doubt and you assume it's true. He hasn't given any account as to where the rest of the money's come from. We know where it hasn't come from. He hasn't given an account that's been excluded.
Well, he's given an account in which he has said he does not have family who can support him, either in Mogadishu, that has been accepted, nor has he got family or relatives in Europe who can and will support him. That is the issue in dispute.
So you say she's excluded the risk that it won't happen.
Yes, she has excluded the.
Very odd way of putting it. She's reached a conclusion. Obviously, if you decide X, naturally that means you're not deciding Y. Usually when you talk about excluding something, it's where a judge has failed to have regard to some particular point of evidence or some particular factor. And the appellant says, well, the judge had no regard to this. There was evidence about it, but it was completely excluded from his or her consideration. But to say she's excluded the risk that it won't happen, it's implicit, isn't it? If you make a finding in relation to the future, if you say that something is likely to happen or will probably happen, it must follow that nobody knows what's going to happen in the future. Any prediction for the future is going to have an element of risk that whatever the prediction is won't happen.
I mean, what she has excluded is the real risk that he will not have the support of family.
The reason why she's excluded that is whenever he's needed it for an agent, for travel, to get out of Somalia, he's had it. And he hasn't given any explanation as to why he had it and why he wouldn't have it in the future. I mean, normally it's executing the account of the appellant. He simply hasn't told her where the money came from. So how must she treat his account and give him the benefit of uncertainty and say, well, you haven't explained where it's come from. You haven't.
But my lord, that's where the language that the judge uses is critically important, because the way that she expresses the conclusion that she arrived at from those facts is merely that it's reasonably likely he would have.
Well, we're back to the
support.
words.
We're back to the words.
We're back to the two words.
The two words that the judge repeatedly uses, she uses them on three critical
the key
occasions.
finding is the one at the end of paragraph 30.
That's the key finding, and it is not a finding which is expressed with sufficient certainty to justify dismissing the appellant's appeal on the basis of that finding.
You say it should be allowed, notwithstanding the fact that she found that he hadn't been frank about his position. You say she had no option on this basis but to conclude that his appeal should be allowed.
If all she was able to conclude was reasonable likelihood that he would have that support, then yes, I would say that she should have allowed the appeal.
Yeah.
But he's got to establish that there's a reasonable degree of likelihood that he won't be supported. He's failed to establish that. One, why? Because he's been helped in the past, and two, he won't tell us where the money's come from. He hasn't established a reasonable degree of likelihood that he won't have assistance, because he has had it when he's needed it.
But that's not what this judge has said. I mean, she's merely said it's reasonably likely he will be supported. And I would say that one has to take seriously the words that the judge uses to express herself and to articulate her conclusions.
I mean, you haven't taken this to Unusi or any of the relevant cases, but at the very beginning, at 13, is it, or 14, she actually identifies the burden of proof. She's not going to be forgotten it a few paragraphs later.
Well,
all the things that she says, I mean, the question to be asked is, would it be unduly harsh if he relocates? You can't leave any factor out of account of that calculation, Unusi and AH. So you've got to look at the country, you've got to look at his circumstances, his age, his education, support, so you look at all of those. So she identifies the test, she then goes through all those factors, and she reaches a conclusion. And the conclusion is the answer on the question. Based on whatever word you want to use, the conclusion on the individual matters. And that's 13 and 14 and 15, isn't it? She says the test is Unusi. 15, the standard of proof is low. It's a reasonable degree of likelihood.
I mean, again, I don't quarrel at all with the way that she's directed herself in paragraphs 13 to 15.
No, I understood that you accept that. So your argument has to be, as you put it, that she did not express herself, that the language that she uses was not sufficient to refuse the appeal.
Well, the language that she uses shows that when she came to deciding the issues before her, she did not do as she had directed herself in paragraph 14. That although she correctly directed herself in that paragraph,
Paragraph 14.
paragraph
14 and 15, the test and the standard of proof.
yes, paragraph 15, the standard of proof. So I don't quarrel with the direction that she gave herself there, but that is not the standard that she actually applied when she came to grapple with the facts and make her.
Well, it's a reasonable degree of likelihood that it would be unduly harsh or unreasonable.
Well, it's a reasonable degree of likelihood that he would be persecuted.
Well, he will be, or he may be if he tries to go to Malawi, because he can't get there because it's surrounded by Shabaab areas.
Yes.
But he's not going to be persecuted, and all the tribunals and the Secretary of State found if he goes to Mogadishu, Shabaab don't have any interest in him and won't follow him there. So we are really down to internal relocation, which I accept is an aspect, theoretically, of well-founded fear of persecution, but it's a separate question whether the individual would be it'd be unduly harsh for him to relocate. That's a very high test. You don't get asylum because you'd be better off in one country rather than another. The burden is on the appellant. It's all of those matters. And it's on him to a reasonable degree of likelihood. And she said, I don't believe you've established it to a reasonable degree of likelihood. Why? Because you've been helped in the past, and the inference is you'll be helped in the future. Her reasoning is as simple as that, isn't it?
Well, her reasoning is as simple as that, but her reasoning is, for that reason, I would say wrong, because a reasonable likelihood of being helped does not exclude a reasonable likelihood that he will not be helped.
We're getting very close to angels on the end of a pin.
Well, I would say we're not. We're
Burden's on him. He's not been honest, she finds. So he starts one down. And your point has to be that reasonable likelihood, reasonably likely that he has a network, that he'd get remittance or whatever, you say is not enough, albeit that he has not otherwise discharged the burden of proof.
There was one further authority I'd like to take you to briefly, if I may. It's
I'm sorry, that's right, isn't it? I mean, there's nothing the other way for discharging the burden of proof that he has to show that it would be unduly harsh. It's these two. We're back to these two factors: the finding that he hasn't been frank about the support and so on, and her findings, albeit that they're couched in language which I fully understand you say is not sufficient, the findings that he would get remittances and would get help.
They are findings which are not arrived at with the degree of confidence that is required.
I understand that submission, but that's what we come back to. Sorry, you were going to take us to another authority.
I was going to take you to one other. I'm afraid I got diverted from the authority I was going to take you to. It's at tab 7. It's KV Sri Lanka. Could I ask you to go to page 1858 of the...
Well, can you just check what the case is about? Just looking at the holder to see what it's about on page 1849. This is about the account, whether an expert doctor, a medical expert, is confined simply to giving medical opinions about the scarring, or whether they can say the scarring is consistent with the account, i.e. is consistent with being beaten with a bayonet or beaten with a stick. Is that the issue?
Yeah, the issue in the case was whether the scars on the individual had been caused at the individual's own request, self-inflicted by proxy, is the term used by the tribunal, that he got somebody else to scar his back. Or were they scars that resulted from having been tortured, as he claimed. And so the issue was, could the appellant's evidence that he was tortured, was that to be believed? Was his evidence sufficiently believable? And he relied upon medical evidence to support his account.
And the question was whether that medical evidence was confined to medical matters to do with the scarring, or whether they could express a view as to whether it's likely to be self-inflicted or inflicted by someone else. Is that the issue?
That was the key issue in the case. But as I say, the overall issue is concerned with how one arrives at a conclusion as to whether the asylum seeker's evidence can be relied upon, or relied upon sufficiently to decide in his favour. And the passage I wanted to take you to is at page 1858. And it's 3, 4, 5, 6 lines from the end of the first paragraph on that page. It says the conclusion about credibility.
Well, we can see the marked passage. You don't need to read it out. Yeah.
So the question is only whether there's a real possibility that the account given is true.
What account?
The account given by the asylum seeker.
But in this case, what account?
In my case, the account given is that he has no family or kin.
She didn't believe that. She said he'd not been frank.
She said there's a reasonable likelihood that he has not told the truth. There's a reasonable likelihood that he has got more.
I find that the appellant has not disclosed the full extent of clan/family support available to him.
And so what she goes on to find as a result of that...
Just we're dealing with credibility. So we're dealing with the appellant.
And as Lord Wilson said in KV Sri Lanka, it is not necessary to arrive at an overall belief in the truth of the account.
But she did.
A real possibility that the account given is true is sufficient. And
Mr. Toll, we're a bit all over the place here. The judge found, as a fact, that the appellant had not disclosed the full extent of clan/family support. You're not saying that that was a finding that was not open to her.
well, this is why come back
I'm
to
not
the...
saying that that's a finding that was not open to her. It clearly was open to her.
I accept it was open to her, but all that she has concluded on that basis is that it's reasonably likely that he had wider family than just his uncle and aunt.
Yes, because
It's
somebody's
reasonable
paid the money.
She goes no further than to find that makes it reasonably likely that he has got wider family.
No.
She does not say...
No, they're two different things.
Well,
one is he hasn't given a proper account of his clan/family support. So she has to make findings or draw inferences from the other material about the extent of clan/family support. And she says, I reasonably infer the personal people who helped the family in 2015 and 2018 and 2019 are reasonably likely to be able to willing to support him again.
exactly. That's what my complaint is about.
So
That is
he's
the
not
conclusion.
told the truth. She's done her best on the other material she has. Those are the findings that she's reached.
Merely that it is reasonably likely that he
Okay,
has
but
got
that's
additional
back
family.
to the same point.
But that surely makes the case that I am struggling to make, which is that she was entitled to... She had that evidence in front of her. She was entitled to draw such inferences as she reasonably could from it.
Yeah.
All that she inferred from it was a reasonable likelihood.
Well, you
that he had
say
family support.
all because you
All.
say that's not enough. So
And
that's
not
back
enough.
to
Yeah.
back to precisely the same submission as before.
The difficulty that I've got is this. There is no doubt that money has passed hands to pay for an agent and 2 flats. It hasn't come from him. It hasn't come from his aunt and uncle. What use can a judge make of that fact? She says, the use I can make of it is he must have more links than he's told us about, because the links he's told us about don't have that money. And there are people who, as she puts it, would be in a position to make remittances. What is wrong with that, given the facts, A, that money has passed hands, and B, he hasn't explained where they've come from.
I mean, I'm sorry to, I'm probably going to end up just repeating myself, but that she's merely concluded on the basis of that it's reasonably likely he's got support, and that a reasonable likelihood is not sufficient. As Lord Justice Brooke said in Quran, a finding on a balance of probabilities would not be sufficient to exclude the risk or to exclude the matter that the appellant relies upon. Here, she's found something even lower than a balance of probabilities. She's found a mere reasonable likelihood that he's got alternative sources of support.
No, she's actually found it at the end of 28. I find the appellant has links with family or clan who have provided him with support and would be in a position to make remittances. That's what she says. It's a finding of fact based on things that are incontrovertible.
Yeah, but what she goes on to find is merely that would make it reasonably likely they would assist in the future. I mean, that's the key fact, is what will happen in the future. She finds merely a reasonable likelihood that they will assist. That is not good enough.
If you'd gone into the witness box and said, well, they've helped me in the past, but I've got 3 letters from here saying enough is enough, you ain't getting any more, that would be his story. And if she said, I don't believe him, we'd have to decide if that was an answer. But he didn't give the evidence that he'd had money in the past, but now no such money would be forthcoming. The people who had given him money had died, or he'd quarrelled with them, or they've run out of money, or they've said, no, you've had as much support as we're going to give. None of that was his story, which was ignored or disbelieved. He simply didn't explain it. And he was on oath, and he presumably didn't say things that he thought would be untrue. So all we're left with is the fact that he has not been honest, fully accurate, in explaining where that money has come from. I just have genuine difficulty in seeing the problem. She's found he's had money. There are people available who can support him.
I mean, I would say it would be unreasonable to conclude from the bare fact that he has been given some money in the past. It would be unreasonable to conclude that alone establishes that he would be supported in the future.
Well,
So your submission must therefore be that he can be dishonest. The judge can have the findings, because she can only make findings about what's happened in the past. And you say, notwithstanding those 2 things, she can't go on to conclude that he'd get support in the future.
That somebody paid for 2 journeys to the UK
Does that
is not sufficient.
answer my question?
I would say that she could not conclude on the basis of those findings.
What's a judge supposed to do in these cases? They've got a less than honest claimant who's had financial support in the past, and you say she can't draw the inference that he'd have support in the future. That's not a level playing field by any manner of means, is it?
What your point was, whatever conclusion she draws, she's got to draw it so that she's sure of it.
Yes.
And yes, he had been supported in the past. She's made those clear findings, but you say the language she uses demonstrates she wasn't certain that he'd get it in the future.
Yes.
That's the end of it.
That's my point. Yes.
Yeah.
And I think
So what's this this business about her excluding things? She hasn't excluded anything. She's just applied the wrong test to you, as I understand it. That's your case. I mean, if there's a real reasonable likelihood of something, then there's a possibility of the opposite. So she's not excluded it. It's just you say she's not been sufficiently certain about it. Have I got that? Have I got it right?
I think that's right. Yes. I mean, I think that a reasonable likelihood that things will work out favourably for him in Mogadishu is not good enough.
Yeah. Okay. Well,
I think that's my.
It's not just that. It's paragraph 29, which you skipped over at the start. She's got reasons for thinking it's going to happen in the future, based on the case that you haven't put in the bundle, that there's a non-negotiable obligation to help one's kinsmen in times of need. and that cultural imperative lies behind the flow of remittances. It's a culturally compelling reason for those to provide assistance. UT found in the OA that there were extensive links and said it's for the appellant to demonstrate why he will not be able to draw on clan or network support. So that's another link in the chain. He's had money when he's needed it. He hasn't been honest about where it's come from. The cultural obligations are such that when you need money, you can call on your clan people or your family. All of that, he's had it in the past. The culture is to support. What more, given that he's not disproved that, does she have to be satisfied of?
Well, one of the things that she needed to be satisfied of is what she's directed herself in paragraph 30,
Which is
that the non-negotiable obligation is not by itself sufficient to establish that he will be supported. He also needs to have a network that will introduce him to that support.
Well, if you read OA, it's slightly different, actually. I do wish you'd put OA in the bundle. I read it on screen on Friday. I couldn't access it for some reason yesterday, but there are large passages there, but you'll correct me if I'm wrong, saying that the way the clan works is through links. I.e., if you contact a clan member, they will find somebody else who can help, but you will tell me whether that is wrong. But if you are going to rely on those sorts of submissions, then in all fairness, we have an obligation to put OA in front of us.
I mean, I certainly was not trying to. I mean, I took the view that the judge had sufficiently described the effect of OA.
Well, she's put the headnote in, but the bit about extensive links comes around paragraph 240 to 260 at a guess. And you've got to go back and read those paragraphs, and you haven't put those in. And they are the foundation. She cites the paragraphs in her judgment. She cites 259 and various other paragraphs. And it would have been helpful at least to have those paragraphs which explain the findings of the Country Guidance Tribunal as to how it works, which supplies the missing link that you, or may supply the missing link, which you're relying on. You've really got to provide that to us, I think.
I beg your pardon, my lord.
You've got to provide that to us, or we're in danger of not having the full picture. We can get it off the internet as long as it allows access to it again. It didn't yesterday.
I'm sorry to disturb your train of thought. You said earlier that if the judge had used the language such as I'm sure that he has a network and so forth, then you wouldn't be here. And is that because the evidence as a whole would have justified that conclusion, but for whatever reason she didn't reach that point? Because if she'd said I am sure and you wouldn't be here, well then that would by definition mean you would accept that all the evidence she's set out, in particular what he didn't say, that would be sufficient to make her sure.
If the judge reasonably concluded that the evidence was sufficient to make her sure, then I wouldn't be here arguing the case that I'm arguing. If the judge said I'm left with no doubt that he would be supported, and that was a conclusion that the judge was entitled to, if that was a conclusion open to her on the evidence, then I wouldn't be here.
But it never could be on this case, because he might always say, no, I may not get it, and you've got to give the benefit of the uncertainty to him. It's hard to see in what circumstances any judge could conclude that it would be not unduly harsh to return to Somalia if the person said, no, I may not get that support. I've had it in the past. I'm a member of a clan, but you can't be sure that it's going to be forthcoming.
I mean, the judge...
No claimant will ever fail, will they?
I beg your pardon, my lord?
No claimant will ever fail.
The judge... I mean, I just come back to the language in which the judge chose to express herself, that she did not...
Understand.
Yeah.
We've got that point. Okay, is there anything else that you want to add?
Just on the subject of the country guidance cases, I mean, I had not intended to place any of the country guidance cases before the court, bearing in mind the length of them and bearing in mind the nature of the case that I have advanced. I didn't think that it was necessary for the court to look beyond the text of the determination itself. I certainly was not attempting to deprive the court of a relevant authority by...
Well, we understand that, and we can look at OA ourselves. I mean, I think that's the case, isn't it? That it's not necessary for us to look at others.
No, it's not necessary to look at others.
And OA, as my lord says, it's a relatively short passage that's relevant to what the judge is addressing at paragraph 30.
It is, and I mean, there's one sentence there which, I mean, she says, I accept that the links necessary to obtain this assistance must be established through an existing network. So that I would say is a question that the judge...
Well, you're now making submissions on the country guidance, which you hadn't intended to make.
No, I'm sorry.
We can look at OA,
yeah,
and we can see whether this is an accurate summary of it.
I mean, I wasn't intending to make submissions on OA. I was just showing the questions that the judge had posed for herself, the issues that she felt that needed to be addressed. And my complaint is about the way that she reached a conclusion on the issue that she said needed to be addressed, namely, did the appellant have a network that would enable him to gain access to the clan support?
Yeah.
But I think I will stop there.
Right, just give us...
I think we probably should agree with that, yes.
Yes, Mr. Malik.
Subject to any observations, what I propose to do is to make 3 short points as to law, and I will then address you as to the decision made below. My first point is that the sole ground of appeal is based on a misunderstanding as to law. The ground of appeal, my lords, is that the Upper Tribunal erred as to the standard of proof in holding that the appellant could internally relocate to Mogadishu. The correct position as a matter of law is that no question of burden or standard of proof arises in relation to the issue of internal relocation. The issue of internal relocation entails an evaluative exercise that is holistic, it is not a question of hard fact. It is a broad assessment of all relevant facts and circumstances relating to the applicant. The decision maker, taking account of all relevant circumstances, must decide whether it is reasonable to expect the applicant to relocate. There are 2 authorities that support this proposition. The first is the judgment in Karen, to which Milan Friend has taken you to. I'm not going to show you the paragraphs again that Milan Friend has showed you already, and the particular paragraph that my Lord Justice Lewis referred to. But may I respectfully show you 2 passages that Milan Friend has not taken you to. And so Karen is
Tab 3, yeah.
yes, it's behind tab 3 of the bundle. And may I respectfully take you to page 477.
Yeah.
And if you look at the very first sentence at that page, you see that the court there said that the issue for the decision maker, the issues for the decision maker are questions not of hard fact, but of evaluation. This very first sentence.
Yeah.
And then if you go to the last page of the judgment, page 480, and see the last paragraph, that in my respectful submission provides a complete answer to the ground as pleaded. It follows, the court said, that on the critical issue of internal relocation, no question of burden or standard of proof arises. The question is simply whether, taking all relevant matters into account, it would be unduly harsh to return the applicant to Colombo.
Yeah.
Now, the second authority is the judgment of the Supreme Court in SC Jamaica. Now, SC is behind tab 8 of the authorities bundle. Now, this is where the Supreme Court reconciled earlier authorities on the subject of internal relocation. If you go to page 210 of the report, towards the end of that page, you'll see a heading, internal relocation. And under that heading, the Supreme Court considers the guidance given in Januzzi and AH Sudan, the lead authorities on the subject. But for the relevant purpose, if you go to page 212 and see paragraph 58, the quotation in paragraph 58, the test, the Supreme Court said, of reasonableness involves consideration of all relevant circumstances looked cumulatively.
So this is the test. I see 57, the test of reasonableness in relation to internal relocation.
Yes,
So that's the test that they're talking about at 58.
absolutely.
Yeah.
Yes. So you look at all the circumstances cumulatively, and then the task of the decision maker is set out in the quotation. Look at all the circumstances and decide whether it is reasonable to expect the applicant to relocate. And the answer depends on an assessment of facts, not on the burden or standard of proof. And then if you look at paragraph 59, this is where there is a reference to AH Sudan, which considered Januzzi, and it was said that the test is one of great generality, excluding from consideration very little. Twice in the judgment, the Supreme Court emphasized on the stringent nature of the test. Firstly, at paragraph 60, first sentence, and secondly, at paragraph 62, at the end, the rigorous nature of the test.
In 62, is that a bit of Latin that's crept in? Because if it is, I'm afraid I don't understand it. Would be unduly harsh, sive, unreasonable, isn't it?
Yes.
Yes, I noticed that.
What does that mean?
Um,
I was no good at Latin and went to a red brick university, so I'm afraid I always have to have Latin translated. It would be unduly harsh.
I'm afraid I
mean,
don't know the answer.
I mean, the short point
Yes.
is that these passages are equating unduly harsh with unreasonable.
Yes, and making the fundamental point that this isn't a question about burden or standard of proof.
Yeah, I
It is a
understand.
holistic exercise. But just in fairness to
Yeah.
to the Supreme Court, the reference in Latin comes from an earlier judgment, an old judgment, Januzaj.
Okay, all right. Well, anyway, don't worry. I mean, that's what you get from 58 to 62.
Yes. Now, my second point concerns my learned friend lines on Sivakumaran. Damir Kaya, this is the authority that my learned friend referred to in the skeleton argument, and KV Sri Lanka. Now, my learned friend has taken you to Sivakumaran and KV Sri Lanka. Now, he says that the question in an asylum case is whether there is a real possibility that an applicant's account is true. The applicant, my learned friend says, is only required to show a reasonable degree of likelihood that he will be persecuted. Now, that, in my respectful submission, is only true in relation to the question of whether the applicant faces a well-founded fear of persecution on return in the home area. Now, when considering that question, the decision maker must apply that standard. But once the decision maker has decided that question in favor of the applicant, the decision maker must then consider the next question. The next question is whether, as the authorities show, it is reasonable to expect the applicant to relocate to a safe place within the country of origin, away from his home area. So the three authorities that my learned friend cites, the two authorities that my learned friend has taken you to, Sivakumaran and KV, relate to the first question as to whether there is well-founded fear of persecution in the home area.
I've got two problems with
Yes.
this submission. Firstly, Lord Bingham in Januzaj conceptualizes why is internal relocation relevant. It's always useful to go back to the beginning. And the reason why he says it's relevant even to look at whether you can go to a part of a country, not the bit where you were threatened, is because he says it would not be a well-founded fear if in fact you could relocate internally. So it is part of the definition in 1A of the Refugee Convention. And secondly, I can see that very often it's rarely going to make a difference, but conceptually somebody must bear the burden of proof. Say nobody gave evidence in the tribunal. Nobody said anything at all.
Yes.
The tribunal would have to decide whether to allow or dismiss the appeal. And the answer in that almost impossible to imagine situation is that the appellant would have his appeal dismissed because the burden of proof does depend on him. It may be that the burden of proof or concepts to do with it don't help when you're looking at factual assessments,
Yes.
but it's hard to say it doesn't arise and it's not the reasonable degree of likelihood.
Well, Lord, I completely understand the point that my Lord makes, but this is what, in my respectful submission, this court has repeatedly emphasized. I mean, for example, in Junaiza or SC, it wasn't said that the question is whether there is a reasonable likelihood that internal relocation would be unreasonable or unduly harsh. The question the court repeatedly emphasized is simply whether relocation would be unreasonable. And in fact, in Karen, as I've sought to demonstrate, the court made it actually clear that the question as to burden and standard of proof do not arise. That is how I would respectfully put the point. So the authorities that assist you in relation to the question of internal relocation are not KV Sri Lanka or Sivakumaran. The authorities that assist you are Januzaj, AH Sudan, SC Jamaica. Now my third and final point concerns the approach that this court should adopt in considering an appeal from the Upper Tribunal. If you have my skeleton argument, I have summarized the relevant principles at paragraph 26. This is page 43 of the bundle. So if you look at paragraph 26, I've set out 6 principles. I've referred you to the relevant authorities. Now these principles are not in dispute, so you do not have these authorities in the bundle. But I do respectfully ask you to look at these principles. Principle 1, in my respectful submission, will assist in relation to the submission that my learned friend was seeking to make. That this court should not rush to find an error of law simply because it might have reached a different conclusion on the facts or expressed themselves differently. The Upper Tribunal, the fact-finding tribunal, is not required to expressly mention every relevant fact or set out every step in the reasoning. The issues that the Upper Tribunal is deciding and the basis on which the Upper Tribunal makes its decision may be set out directly or by inference. There is no requirement on the fact-finding tribunal to refer expressly to the case law, and the nature of the exercise is that different tribunals may reach different conclusions on the same case, on the same facts.
I mean, all of those apply whether it was a tribunal or a lower court. All of those points of principle.
Yes.
I mean, we would apply, I think, all of those to a decision by a circuit judge or a high court judge.
Yes, absolutely. But a further point that one gets from these authorities is that Upper Tribunal is a specialist tribunal.
I understand that point. I couldn't help, my eye was caught when Mr. Toll took us to KV Sri Lanka. My eye was caught by a passage in the judgment of Lord Wilson where he says, in paragraph 12 of his judgment in SS Iran, Lord Neuberger observed that appeal courts should be particularly wary of interfering with evidential conclusions made in relation to claims for asylum, in which, among other things, the paucity and fragility of the evidence are likely to be acute. So I marked that passage, but that's only really putting a couple of these points in a slightly different way.
So when you will consider the Upper Tribunal's decision having regard to these principles, in my respectful submission, you'll come to the conclusion that Miller and Friends' complaint is a mere disagreement with the outcome. Now you have, of course, seen the Upper Tribunal's decision.
Yeah.
Page 49 of the bundle, you have an extensive quotation from the relevant country guidance at paragraph 11. Miller Friend has taken you to that paragraph. Miller Friend asked you to look at paragraph 14 of the quotation, but you may also wish to see paragraph 5 of the head note, where there is a reference to Somali culture and the links.
Yeah.
That paragraph is at paragraph 54.
Yeah.
And then just looking at page 56 of the bundle, if you look at Roman 9, you'll see that these are the matters that the Country Guidance Tribunal said are likely to be relevant. And included in the list is availability of remittances from abroad, access to financial resources, means of support during the time spent in the UK, and most importantly, the final bullet point, why the ability to fund the journey to the West no longer enables an appellant to secure financial support on return. Paragraphs 13 and 14, the judge makes 10 different points in the appellant's favor. I've summarized those 10 points at paragraph 18 of my skeleton argument. There is then a self-direction Milan friend accepts, which is entirely correct, at paragraphs 14 and 15. And then between paragraphs 16 and 32, the Upper Tribunal, in my respectful submission, conducted a holistic evaluative assessment of all relevant circumstances. Now, the focus of Milan friend submissions have been paragraphs 28 to 32, but it may also assist to look at the earlier paragraphs as well. You can see that the Upper Tribunal considered issues of transport and availability of remittances, potential financial support from others, age of the appellant, circumstances of his travel to the UK, lack of contact with a mother, his financial circumstances, his income, lack of other family connections, possible ways to seek assistance in Mogadishu, the security situation, humanitarian considerations, and culture of Somalia and social network. This, in my respectful submission, is a model assessment of the issue of internal relocation. There is nothing more that this judge could have done or could have said. When considered in the context, the phrase reasonably likely is not objectionable. It is perfectly legitimate, in my respectful submission, for a judge to use that phrase in the circumstances where the appellant, on the findings made by the judge, was not entirely honest and had not given an adequate account of how trips were funded. He had not disclosed the full account of the support available, and he had not been forthcoming. This is paragraphs 28, last sentence, paragraph 29, second last sentence, and paragraph 32, last sentence. Milan friend, with respect, is simply wrong when he submits that the judge should have expressed herself in terms of certainty, or should have applied a criminal standard. That is not the standard that applies. As the case law demonstrates, all that is required is a holistic assessment of all relevant facts, and this is what this judge did. But even if I'm wrong about that, the complete answer in my respective submission is in paragraph 32. I find, the judge said, the appellant would have remittances from abroad and some planned sport. This is a clear finding, which in my respective submission is fatal to the appeal. Simply nothing wrong with this decision, and there is no error of law. Unless I can assist you any further, for these reasons, I respectfully invite you to dismiss the appeal and uphold this decision.
I wasn't quite sure, and again, I'm sure my fault. The respondent's notice.
Yes.
What was that adding to? I mean, we understand your submission that there was no error of law, so that's that.
Yes.
Your additional ground,
Yes.
seems to reflect your submission that questions of burden and standard of proof are nothing to do with
Yes.
internal relocation,
So
which
it's
is
the
really
second
where
point
you
that I made.
started. Yes,
Yes.
absolutely. So really, it's part of your reasoning as to why there's no error of law.
Yes.
It's not. It's not beyond that.
No, no. It's just that we felt it appropriate to put in the respondent's notice because the judge did not expressly say that the question of burden and standard of proof do not arise in the context of internal
Oh, I see.
relocation.
So that's a sort of out of an abundance of caution
Yes.
approach.
Yes.
I'm still wrestling with this.
Yes.
Somebody has got to prove something or they
Yes.
lose.
Yes.
I understand all the arguments about it's not the criminal standard, sure, it's not the balance of probabilities, it's reasonable degree of likelihood. But I understand that the nature of the exercise is really, is it unreasonably harsh, work your way through the facts and reach a conclusion. But there is a burden of proof. It's on the appellant to show to a reasonable degree of likelihood. I mean, it can't be on no one, can it? To say that it's
Well, I said respectfully, I understand the point, but both this court and the Supreme Court, the message was that it wouldn't assist fact-finding judges to refer them to the notion of burden and standard of proof and considering the issues of internal relocation.
I understand that it's unlikely to be helpful in virtually all cases.
Yes.
But something deep within me says theoretically
Yes.
there must be a burden. I suppose because I went to a law school and I was told there must be one. But there may be no more than that.
Yes. I mean, if for example, there is a safe haven within the country of origin, and the appellant simply says nothing about it, a judge will look at all the circumstances and will conclude that internal relocation is not unduly harsh, it's reasonable, rather than saying that the appellant has not proved that internal relocation is not.
Just change the facts. So what if the appellant had said, yeah, I did get help for the agent. I did get help from for the flight. That was my great uncle. I loved him very much, but he's dead. And there's no more money. What's the position then? If the tribunal thought, well, that may be true. I don't really think I'm sure it's true as well. Wouldn't burden and standard of proof be relevant then?
Well, the fact finder would make findings of fact. A fact finder would find, for example, if the fact finder accepts the evidence that the great uncle is dead and sport is not available, the fact finder would make that finding and would then put that finding into the equation.
Yeah.
That would be a circumstance, one of the very many circumstances the fact finder would look at.
Yes. So the fact finder
Here
would.
the circumstance is not that great uncle is dead, just a complete void as to where the money's come from.
Yes, or the age of the appellant, the ability to find work, the ability to be self-sufficient and so on. The fact finder will look at everything cumulatively and decide whether internal relocation is reasonable. If, for example, you have an appellant who is seriously unwell, who is not able to work and make a living, there is a good possibility that internal relocation would not be reasonable. But if you have an appellant who is healthy, fit to work, despite there being no sport, a fact finder can legitimately find that internal relocation would be reasonable.
So we know what the question is it unduly harsh? You know you've got to work through all the relevant circumstances and you're going to reach a conclusion on those circumstances. And then having done that, you've got to go back to the question and say, right, in the light of the circumstances I find them to be, is it unduly harsh? And in those instances, it's unlikely that reference to burden or standard of proof is going to be with us.
Yes. Well, I mean, given that the point is troubling you, there is some analysis in a recent judgment by Lord Justice Singh as to this question. You don't have that authority in the bundle, but we have copies for you in case you wish to see it.
Which case is that?
This is MAH Egypt.
Okay, we better have a quick look at that.
Yes.
Don't worry, but if we have that, if we've got it here.
No, we don't. Yes, we have the spare copies. Yes.
Thank you very much.
Thank you very much.
Now, if you go to page 49 of the authority, you'll see a heading standard of proof in asylum cases. This is not about internal relocation, but a general question as to the standard of proof in asylum cases. And the observation that points to a different direction than the direction that Lord Justice Lewis had in mind is paragraph 51. Strictly speaking, it could be said that it's not entirely accurate to refer to this as a standard of proof.
Yeah.
The applicant does not, in fact, have to prove anything. It is essentially an assessment of risk.
That's helpful, yeah.
Okay.
Yes, but I do respectfully emphasize that this is not on internal relocation, but generally on the standard of proof in asylum cases.
Yeah.
I just felt it appropriate to bring that to your attention, given the question that you asked a lot. So unless I can assist you any further, these are my submissions.
No, thank you very much,
Okay.
Mr. Malik. Yes, Mr. Toll, anything in reply?
Yes, thank you. On the place of the burden or standard of proof in asylum cases, it's true that Quran does indicate that terms such as burden of proof, standard of proof are potentially inapplicable, and indeed that evidence may be an inapposite term. But that is both in respect of the question whether the person has well-founded fear of being persecuted, and also in respect of the question of internal flight. And the reason why question marks are placed over burden and standard of proof is because of the nature of the decision-making process. Could I ask you to go to Quran again, at page 465? Just below the letter G, Lord Justice Brooke refers to the Australian case of Wu Shan Liang. He talks about the standard of proof to be adopted in an administrative fact-finding process of this kind. And quotes from the case, he says, submissions were made at the hearing of the appeal as to the correct decision-making process which it would have been permissible for the delegates to adopt.
Well, we can read this for ourselves. Just give us a moment.
Could I ask you to read to D on the next page?
Yeah.
And then could I ask you to go to page 477, which is Lord Justice Sedley's judgment.
Yeah.
So what do we get out of what we've just read? Or what does it show us that's helpful in this case?
It shows that As I understood my learned friend's submission, it was that when one is dealing with internal flight, there is no burden or standard of proof that arises. And I just wanted to take you to the reasons why it is said that there is no burden or standard of proof. And it's not because of the nature of the internal flight issue, it's because of the nature of the whole decision-making process.
So are you accepting now then that burden and standard of proof isn't an appropriate phrase to be used for internal flight decisions?
Well, Quran certainly says that the language of burden and standard of proof is not appropriate to the administrative decision-making process, which is involved in asylum cases, and that appeals against asylum decisions are said to be extensions of that decision-making process. However, the case that you were most recently referred to, the MAH Egypt case,
Yeah.
I mean, you have Lord Justice Singh there still talking about burden and standard of proof, even though he knows that, or he acknowledges that authority that, strictly speaking, those are in apposite terms. So you were taken to paragraph 51. Strictly speaking, not entirely accurate to refer to this as standard of proof, because the applicant does not in fact have to prove anything. It could more accurately be described as being an assessment of risk. So it is an assessment of risk done first of all by an administrator and then by the appellate process, which is to be seen as an extension of the administrative decision making.
So are we dealing then not so much with burden and standard of proof, but assessment of likelihood of harshness?
We're dealing with assessment of risk, whether risk of being persecuted or risk of, or with the question of whether it would be unduly harsh. And the question with which Quran in particular is concerned, I would say, is about the evidence which is relevant for the purpose of addressing those questions and the degree of certainty that the evidence or the material needs to instill in the decision maker.
So before you exclude a risk, the degree of certainty you must have in order to exclude the risk.
Yes, I mean, unless you have no real doubt that the facts are not as claimed by the asylum seeker, then the assessment...
We've been over that, that's not this case. Because the asylum seeker didn't have an explanation. So this isn't a case about, well, I say X and the tribunal saying, well, no, I reject that.
Well, I would say it is. I mean, the appellant has said X, which is that there is nobody to help me. The tribunal has said, well, actually, there's a reasonable likelihood you will be helped.
So what the tribunal said is, well, hang on a moment. You have been helped twice. Somebody paid the agent, somebody paid the flight. And
so the conclusion that the tribunal reached from those historical facts was that there is a reasonable likelihood, no more than a reasonable likelihood.
We've been over that. That's not a point of reply.
That's not a point.
Is the answer to my Lord's earlier question, though, do you accept that language of burden and standard of proof is inappropriate?
Well, that would seem to be the message of, that would seem to be the result of Quran. But in the knowledge of what Quran says, Lord Justice Singh continues to talk about burden and standard of proof.
And I'm asking you, Mr. Toll, whether you accept that the language of burden and standard of proof is inappropriate in this case.
No, I mean, I would say that in practice it makes no real difference. That, and I would treat Lord Justice Singh's judgment as supporting that proposition. And that the question is, how does one evaluate the evidence and the facts, and what degree of certainty does the evidence enable the decision maker to arrive at? And as I say, unless the decision maker is able to reject factual claims as being ones about which there is no serious possibility that they are, as the asylum seeker contends, then the assessment of risk should be made on the basis of those factual claims.
Yeah.
And for that purpose, I'm relying on what Lord Justice Brooke said at page 470, where he made it clear that the evaluative exercise is the same whether one is dealing with the question of fear of being persecuted or internal relocation. That there is no distinction to be drawn in terms of the method to be applied to the assessment of the facts. With regard to SC and Januzzi, I would say that neither of those cases deals with the issue that you are having to deal with. SC and Januzzi were about the substance of undue harshness or unreasonableness. They were about what considerations are relevant to the question of internal relocation, what considerations are not relevant. That neither case was concerned with the way in which a decision is to be made on a particular factual matrix as to whether it is or is not unduly harsh. That's why I didn't take you to those cases in my case. I say that they do not touch upon the issues that you are concerned with. I think that is. May I just have one moment before I conclude? Just.
No, he's right on SC and Januzzi, actually, yes. I'm not going to see right on SC and Januzzi, but I think we shouldn't get into this.
It's a slightly odd position to be in an appeal.
My lords, that's my reply.
Okay, thank you very much. Right, well, thank you both very much. We will reserve our judgments, although it would be reasonably helpful because in this case the point is relatively short and obviously important to the appellant. We will endeavour to provide our judgments as soon as we can. They will be provided in draft. That's an opportunity for you to correct our grammar and typographical errors, but it's not a reason or an excuse to re-argue the case. The draft judgment will be available to those who have provided, those who are named on the list which has been provided, and it is confidential. So as you both know, it is only for the people on the list to see, and there are significant consequences if the confidentiality is breached. So it's very important that that is adhered to. When you have commented on our typographical errors, we hope that you'll be able to also agree an order at the same time. If for whatever reason you can't agree an order, then please provide an order with the competing bits that aren't agreed in square brackets, together with very short submissions on the points in issue, and we will decide the order at the same time as handing down the judgment. The judgment will be handed down electronically, so there won't be any need for any further attendance. All right, thank you all very much.